We had the continuation of Dr. Marie Russell's Daubert hearing, which occurred 2 days ago. We live streamed it right here at Brother Counsel Studios. If you're able to join us, that was great. We had a good time talking and chatting and really breaking down what was going on real time as it was actually happening. And if you were not able to join us, well, we did do a recap under 40 minutes of video of just kind of recapping everything that happened during that 7-hour Daubert hearing. So today's video, we're really going to be concentrating on specifically Hank Brennan and Hank Brennan's performance. And the reason is that a lot of people are talking about Hank Brennan. People are saying, is he good? Is he bad? Is the jury going to like him? Is the jury not going to like him? Is he too strong? Is he too sarcastic? Is he too snarky? So we're going to be talking about all that today. And I'm going to be showing you specific clips in which I thought were some highlights from Hank Brennan. Now, one thing I do want to say, which I've been saying right away since I've been seeing his motions and seeing him argue, is that he's a formidable opponent. He is going to be a very strong opponent against the Karen Reed defense team. I think it's going to be very different than what we saw with Adam Lally. Adam Lally, he's also a smart guy, I think. I think he did the best that he could with the evidence and the facts that he had to deal with. But you can just tell a different approach, a different type of fight with Hank Brennan that you're going to have as opposed to with Adam Lally. So he's going to be a thorn in their side. That's definitely true. He's filing motions. He's trying to strike Richard Green. He's trying to strike the ARCA experts, which he still hasn't filed that motion. But don't worry, when he files that motion, we're going to break it down. We're going to do some research and see if there's anything for any merit in that motion at all. So he is attacking like a pit bull on this case, and he's really trying to win this case for the Commonwealth. And you can tell he's very good at his job. He's very fierce. His arguments are very strong. He's very confident, and he's definitely a formidable opponent, as I've said. So it's definitely going to be a harder win for the Karen Reed side. Okay. So before we jump into the actual clips of what I thought were some of the highlights, and we're going to go through some of his tactics and strategies and perhaps how to counteract those strategies and tactics. Something that I do want to mention also, something that you noticed right away, and this is just something that, maybe some of the more experienced attorneys notice from different lawyers when they're trying cases or when they're on their feet in court. Certain lawyers just have something called courtroom presence. Okay. And it's very difficult to teach. It's something that you either have or you don't have. And a lot of times it comes with just experience, just your comfort level, your personality, your confidence. There's a lot of those factors together, and that can equal courtroom presence. And when you have courtroom presence, it can be very helpful. Now, it's not necessary. A lot of lawyers can win cases without courtroom presence. You can, you know your case, you know your facts, you know your evidence, you present it to the jury, and you make your arguments and you win. You can do that. There's no problem with it. It's just a nice added feature that you get to see with really good experienced trial lawyers. It's something that you notice when Alan Jackson gets up and talks, when he argues, it's like everyone's quiet as everyone's listening to what he has to say. You know it's going to be smart. You know it's going to be intelligent. You know it's going to be to the point. You know it's going to be articulate. So it's just that courtroom presence that Alan Jackson has, David Yannetti has, definitely Robert Alassi has it, and it's something that you also notice with Hank Brennan, and perhaps even a little bit more than Adam Lally. Now, again, I'm not saying that Adam Lally is not a good attorney. I think that he did the best that he could, given the facts and evidence that he had. But still, it's just this extra feature, this extra asset that you can have as a trial attorney to have this courtroom presence. And it's something that right away stuck out to me with Hank Brennan. When he gets up, when he talks, he's extremely confident. He says his points, and he is just exhibiting this courtroom confidence, this courtroom presence. So it's just something nice to see. And like I said, this trial that we're going to be seeing now, and the second trial, is going to be a clinic for trial lawyers. These are all A-level attorneys, and it's going to be very interesting. And I think it's going to be a little bit different than what we saw in the last trial, because Hank Brennan is a pit bull. He's very fierce. He's very strong, and it's going to be very difficult. I mean, it's just going to be more difficult for the Karen Reed side, to combat that. It doesn't mean that they're not up to the task. They have a great defense team as well. But I'm just saying, I think we're going to be seeing a lot of very slick lawyering and very strong arguments and things like that. So it's something that we're noticing already. We're seeing that Hank Brennan's filing all these motions, trying to strike all these experts, Richard Green and the ARCA experts. So today we actually got to see him in the Daubert hearing, to actually see some of his performance as he's cross-examining a witness. Okay, so let's pull up the video, and I'm going to play different clips, which I thought some highlights from his cross-examination. Dr. Russell will talk about it, and I'll give you some of my opinions about what he's doing. Now, the first thing that I want to point out here is that in the beginning of this, and I was talking about this during the live stream as well, is that when you have this Daubert hearing, okay, so things can really get convoluted and confusing very quickly. And if you're not on top of your game as a lawyer or as a doctor or the expert here, things can really get confusing, and you can really fall into traps very easily. And I think that that's kind of what Hank Brennan was really doing here. A lot of what he was doing here, I think, was strategy, was tactics in order to kind of confuse Dr. Marie Russell, in order to try to get her to concede on certain things and to admit to him certain things. And sometimes when you're in this type of back and forth cross-examination with an attorney, at some point it just gets tiresome, and you may feel like, okay, let's just agree on something. And therefore, and you don't realize that as the expert, you may just be damaging the other side's entire case, or damaging your opinion by admitting or conceding to the attorney something. So you got to be careful about that. And that's something that I noticed that really, I think Hank Brennan did a lot of times, especially in the beginning of this hearing, when he was talking a lot about methodology. You kept hearing him say methodology. You kept hearing him saying about standard and standard for comparison. And it was almost a little bit convoluted. And I was pointing this out during the live stream. At what point are you talking about standard, and at what point are you talking about methodology? They're really two different things. Okay. A standard is the framework. The standard is, has this methodology been accepted in the scientific community? Is this grounded? Is this, what type of standard does this methodology have? Methodology itself is the process in which the expert goes through in order to come to their opinion. So it's just a certain methodology is the process in which they get to the opinion, and the standard is just the framework. Is this methodology accepted? Is everything that the attorney, that the expert is testifying about, grounded in and accepted by the scientific community? Has it been subject to peer review? What's the potential rate of error? That's standard. Methodology is your process, how you actually went about coming to your actual opinions. And I see that he was kind of mixing these two up, because I think he had a little bit of an idea that there's no real standard dog bite. And he was mixing up, I think, these terms. And I think some of it may have been purposeful to try to win a big win here, that in order to say, you don't have like a standard picture of a dog bite, and then that's what you're supposed to use to always compare it to other wounds and say whether it's a dog bite or not. Now that's a different type of standard than the standard that's required in a Daubert hearing. Standard, again, in a Daubert hearing is, has this been accepted by the scientific community? That's what the standard that you need to prove in a Daubert hearing. And then you have to prove your methodology, that your methodology is sound. The process in which you went through is sound. Now, again, he throws a lot of these terms around, and I think part of it was to confuse her and to get her to concede on certain things that you really don't have a standard, and therefore you really don't really have a good, solid methodology. So I'm just going to play for you this one clip, which you see kind of how he's mixing and matching the terms that he's using, and to try to confuse, I think, Dr. Marie Russell. So here we go. This is in the beginning.
But what you're saying is that there's a methodology in identifying dog wounds. I'm asking you, where does that standard come from?
Okay, so there you go. You see that at one point he's talking about methodology, then he's saying, okay, well, where does that standard come from? Really, again, like I said, they're two different things. Methodology or standard, which one do you want to talk about? But he does this a lot. If you notice, I'm not going to play for you the first 20 minutes of this, but that's what he's doing with this circular type of questioning about the standard. Where's the standard dog bite? What does it look like, and how do you compare it? And he really hinges and bases a lot of his argument on the fact that there's no real standard dog bite that you're comparing your results to. And that to him is a very big point to make. And then once he's trying to get her to agree that there's no standard dog bite that you're comparing things to, so then that's going to make your opinions not scientifically sound. Okay, so that was just one thing. Let's move on to another area where I thought he also was a good job by Brennan. So let's move on. It's not here. It's 39.9. Okay, here we go.
Through that process?
I did.
I didn't see that anywhere in your report
It's in
whatsoever.
my head. I didn't write it down.
Well,
So he's talking about all the different, when she was going through this differential diagnosis, it was where, you don't just say that this looks like a dog bite, but you have to also, as a doctor, she's explaining, after the doctor, you have to rule out what else it could be. So, you have to go through, okay, could this be from a car accident? Could this be from a self-inflicted wound? So she goes through a lot of this, and his argument here is that you didn't put any of this in the report. Now, again, it's always the question. Anytime that you can find anything that the expert did not put in the report, obviously you bring that out in cross-examination. But also on the other end, on the other side, the expert's not going to talk about everything in their report, right? They're not going to talk every single little thing in their report. They're going to tell you their main conclusions, how they came to it. And, so anytime that you can find anything, that's what he's kind of hanging his head on here, that you did not put certain things that you ruled out in your report. So let's listen.
aren't you supposed to report the process you go through before coming to conclusions? Isn't that why you wrote a report and discovery and disclosure?
Yes, but
Okay. Is there anything else in your head that you thought about that you didn't put in the report or tell anybody? So we have car accident.
So you see that's just great cross-examination. Okay. When you can point out something to the expert that, yeah, I didn't keep that in, I didn't put that in my report. And then you could just leave it there, and a lot of attorneys will. But then just to really slam home your point, you can always ask the expert, is there anything else that you left out of your report? Is there really, like, what else are you not telling us? And it really makes the expert and the witness look like they're trying to hide information. So it's, as a simple thing of like, of course, we're not going to include everything in your report. And this is what you have to do on redirect. On redirect, what you have to do is you have to tell the expert, okay, did you put what color the sky was in your report? Did you put all this irrelevant information in your report? Well, wow. So it looks like you just left so much out of your report. And then you kind of bring back the point that you don't need to put all that stuff in the report. But still, and for cross-examination, when you find something, even you find one thing that the expert forgot to put in the report, then you just slam it home. And this is what he's doing. And this is what I like to do also, is that you say, well, is there anything else that you forgot about? Is there anything else you're not telling this jury about or telling this judge about? Is there anything else you're trying to hide? And you lead them down that path. So it makes them look like a real liar. So that's something, again, it's just that extra little bit that these really good experienced attorneys, when they will just slam home the issue instead of just leaving it as, okay, I scored a point because I showed that she left something out of her report. It's just another way to really slam it home. Okay, let's go ahead a little bit more.
Accident, differential diagnosis.
wasn't in.
To think about it.
Well,
Here.
no, I don't think so.
Well, was there any other significant causes that you went through and vetted through differential diagnosis that you didn't write down?
Okay, so he's continuing with this line, like, is there any other different differential diagnosis that you didn't write down? Going back to that theme. And once you have it once, and you can show it again and again and again in the same witness, oh, is that something else you forgot to tell us? Is that something else you forgot to tell us? Like, you just keep hammering it home, and it really looks the person like they're on the defensive. So look what he does here.
Not that I remember it this time.
And that's why it helps to write it down.
Right? I mean, look, he's saying, okay, that's why it helps to write it down. You can't think of anything else right at this time. And this time you can't think about something else. Well, maybe there was something that you just forgot to write it down, which is why it's probably very good to write these things down, isn't it? So it's just good technique. It's good strategy. And it just shows how he's on a different level than a lot of other lawyers. Because, you just come back, you really hammer it home. And, again, this is not in front of a jury. So this Daubert hearing is in front of a judge. The judge kind of knows your tricks and everything. It's not as impressive when it's in front of the judge, which is why a lot of this could have been taken out. A lot of this was for the theatrics. A lot of it was because they know how publicized this trial is. So that's why this Daubert hearing took 2 days when it really probably could have taken, 2 hours. But a lot of it's theatric, but you can kind of see how this is going to be presented in front of the jury as well. So it's not going to really impress the judge that much because the judge is above these kind of tricks, but you're already seeing some of the way that his approach to this is and how it's going to appear to a jury. Okay, let's move on. Let's go to another area.
Years, isn't it?
I gotta go to.
Correct.
Just bear with me one second.
You know what
Really?
wasn't found for trace evidence in that sweater? DNA of a dog.
So now we're getting back to the DNA of the dog, right? Remember that she was testifying how this is a dog bite, and then we know that that sweater did not have any DNA from the dog, and I know that all of them were swabbed, all those areas were swabbed, and listen to what he does here.
I understand that.
You know when dogs bite, saliva, foam, sweat in their mouth, correct?
I also understand that there were issues with the collection.
Well, we're going to get to your claims and see if there's any basis for it, but that's not the question I asked you, but I will invite you to talk about that in a second. Looking forward to that.
Okay, now that's something that just a more experienced attorney is able to just kind of spin it right then. If you're just following an outline and you're just going by the book, then you may not pick up on these low-hanging fruit where you can slam home your point. Okay, he knows that she wants to talk about the DNA. He knows that she wants to say how the DNA doesn't disprove her theory, and right, the absence of evidence is not evidence of absence, and all that good stuff. He knows that she's dying to say that, and as an attorney, when you're cross-examining it, you're not going to just let her say it when she wants to. And you're even going to say, I know you want to say that. I know you want to argue that. And then you also turn it into her claim. Okay, you hear the way that he's saying, the way that he phrases what she's trying to do as, I understand what you're going to try to claim in this case. And that's just a way to discount her opinion by phrasing it that way and coining it that way. So that's number one. And then also number two is, don't worry, we're going to get to that. I'm looking forward to that. Meaning, I know exactly what you're going to do. I know exactly what type of argument you're going to make. And you're letting, again, this is in front of the jury. It's a lot more persuasive than in front of a judge. But in front of the jury, if you can kind of picture how this is going to go, you tell that, I know where you're going to go, and I'm fine with it. I'm looking forward to it. I can't wait to talk about that. And right away, what you're doing is, number one, you're getting this witness a little more nervous because this witness already thinks, whatever witness is, whether a regular witness or an expert witness, right away, they may not be as confident anymore because they know something's coming. And then they're thinking about, I'm not so confident about what I was going to say about the DNA. They start rethinking it. And then you start with other questions. So they're already thinking about this other topic that you're going to cover. And you go back to some other topics, which they're not really 100% concentrating on because you just spoke about the DNA and say, don't worry, we're going to talk about that. I'm looking forward to it. So they right away are thinking about this other topic right now. She's thinking in her head right now about this other DNA topic. And I wonder what he's going to say and what he's going to ask. And now if he asks other questions, she's not really concentrating so well on those other questions that you're going to ask. And leave that. Just keep pushing it off. Keep pushing it off till later. And then that way you may get some great admissions and concessions from this witness right now because they're not really 100% focusing because they're already anticipating what you're going to be doing about this DNA questioning. And then you may push it off even longer and longer and longer and longer so you can get all this other stuff that she's not really concentrating as much about. And then actually she may be thinking, okay, phew, you're going to be done. You're not going to ask about the DNA. And then you come back with the DNA stuff or you come back with whatever you were pushing off to the end. So again, this is just something it's something that you're seeing from a very experienced attorney, which is why Brennan is good. Okay. He just is good. You can tell lawyers who are watching this will be able to tell you that he's definitely doing a good job. And there's a lot more going on behind all these tactics than what you may be seeing during this trial. A lot of psychology and things like that. So let's just play one more clip for you guys. And just another area of what he did. And again, it's always good, something that he's going to do here now also, it's always good to be able to try to show how the expert really is trying to win the case for their side instead of just being an objective, independent witness. So when he says, I know what you're trying to claim in this case, it sounds like he's putting her together with the defense in this case. You guys are all on the same side over there and you're all trying to claim all this garbage, right? Instead of, this is a doctor who's really technically independent and she just wanted to give her opinion about something and that's why she's here. But when he phrases it as, I understand what you're going to try to claim, just like with the defense. I know you're trying to help them out. You say things like that, and then the jury can start thinking, yeah, this is an expert who's really on their side. And that's why they're so strong in trying to claim all these things. Okay. All right. So let's just move on to one more clip here.
No.
Because many times you've interrupted and tried to talk about a suggested or a supposed taint that doesn't exist. And I'm just curious, why is it so important?
And you see how he does that, how he just throws in that doesn't exist? Yeah, she's trying to keep saying about this DNA, and he keeps pushing her off. And by the way, he keeps pushing her off because then she's going to try to inject it and interject it and try to keep talking about it because she wants to talk about it. And he'll keep pushing it off, and then she'll keep trying to put it in, and he'll say, why do you keep trying to talk about this? This is all strategy. It's like ballet, it's like trial lawyers ballet. It's like, this is all thought out. And that's what's really cool about watching these good attorneys, that he knows she wants to talk about the DNA. And you notice we're already going a few more minutes into this video, and he's not letting her. And then finally says, you know what? You really want to talk about this DNA because you want to say that there's some sort of taint that doesn't exist. Kind of throw that in, which is completely argumentative. But, like there could have been an objection for this question, but it's just like so natural, just rolls off the tongue. And for these attorneys, he's not reading off a script now. He may have a few bullet points that he wants to cover, but that type of question, that just rolls off, experienced attorneys. I understand you want to talk about this taint that doesn't exist. I'm just curious, why is it so important? So listen to this.
If you discount dog, why is it so important for you to discount the fact that dog DNA does not exist on any of those holes?
So like he's like, why is it so important for you? And there's going to be objection here, but why is it so important for you to help the defense? Why do you really want to help this defense? And again, the point is because if you're just here to be an expert, if you're just here to just share your knowledge, why is it so important for you to try to win the case for them and argue as a lawyer? And sometimes that's something that I'll tell the witness. Are you trying to be the lawyer now? Like, are you really trying to help them so badly that you wish you were a lawyer in this case? So like that's kind of what he's doing here, Hank Brennan. And it was something that was, I thought, and there's a number of instances like this where it sounds a little snarky, it sounds a little sarcastic, but at the same time, at the same rate, if you get an independent jury there hasn't been following this case and just sees what's going on, as an attorney, you can really try and to get this witness to look like they're really just saying whatever they want to say, whatever they need to say in order to help that other side win. So like that is really what you're noticing here and how he's trying to paint her. And this is something now that the defense sees what type of cross-examination he's going to have. The defense could then talk to Dr. Marie Russell. Now, this is always you have to be very careful with this because you are allowed to talk to witnesses as an attorney, right? You're allowed to talk about witnesses, and it's not protected under attorney-client privilege because it's a witness. So you're allowed to talk to the witnesses, and in fact, that's a jury instruction that the attorneys are allowed to talk to witnesses, or you've heard that witnesses have been interviewed by attorneys. That's completely fine. There's a specific jury instruction about that. But the idea here is that you got to prepare Dr. Marie Russell about how to deal with this type of strategy, with these type of tactics. Make sure she understands standard methodology, things like that. And then also, just when he tries to paint you as someone who's just here to help the defense, you have to be able to explain to him that, no, I don't really care that much. I'm just trying to help out and give explanations of different possibilities or things like that. So, but then what can happen then is something that we all do as trial lawyers, is that we will ask the witness, have you spoken to the defense attorney in this case? When was the last time you spoke to the defense attorney in this case? Oh, last night. How long was that conversation? And it's not protected. You're allowed to talk about all that stuff. You're allowed to bring that all out in cross-examination. So you have to be careful about, talking to Dr. Marie Russell, but still, I think it's still worthwhile to prepare her. And, she doesn't have to say every single conversation. She can say, yeah, of course, we spoke to, I spoke to the attorneys. They told me to tell the truth. They told me to be, just honest and objective. And that's exactly what I did, and as the person cross-examining, the attorney cross-examining the witness, you try to bring out more stuff. Oh, that's all you spoke about? So it's you got to be careful with this, but still you have to prepare your witnesses. And you don't want the jury to think that Dr. Marie Russell is just coming here because she wants to get Karen Reed off. You have to paint her, and when you're Alan Jackson, when you're the defense, as a completely objective expert in this field who's just here to help you understand what you are seeing. So again, I think, like I said, Hank Brennan is a formidable opponent. I think we're going to be seeing a lot of very slick lawyering in this case. We're going to be seeing some more motions filed in this case. We're going to be having some more hearings on this case until the eventual trial. And I don't think yet, by the way, we have an official trial date. I know that it's at least till April 1st, but we don't. I don't think she actually set that in stone yet. But it certainly seems that's where we're headed with all this pushback from Hank Brennan. All these motions are going to be filed and new Daubert hearings with Richard Green and all that stuff. So anyway, we're going to keep following the docket and following these hearings that are going on. We'll be breaking them down in our objective way like we always do. That's going to be it for now. If you haven't yet, please subscribe, like, and we will see you next time.